don't know where they are. I'm so sorry. I don't know where they are.
It's not your fault.
Sorry, that Martin said I didn't know.
It brought me in without the council. Well, we shall sit down and wait.
Poor Ben.
This hasn't happened before.
You'll be mortified. Are we 30 seconds early?
Yes, we are. I'll apologise to Mr. Cooper on the basis that I'm uncharacteristically early.
Sorry to have kept my lord waiting.
Mr. Cooper, there's no need to apologise. Uncharacteristically, we've arrived early. Unbeknown to me, we came in 2 minutes early, so no apology is called for.
Right.
Thank you.
My Lords, my essential proposition is set out in our case, I think, at paragraph 14, that it's that the right to retrial in section 20, subsection 5, means a right to apply, as you well know. It's my submission that does no violence to the language of the statute. I saw in passing this morning that it seems that before Mr. Justice Chamberlain, at a very early stage of my involvement in this case, I suggested that might require a read-down of the statute. Well, on more mature reflection, that is not the submission that I make to this court. The submission I make is that a right to retrial means a right to apply. And I was thinking of examples where that pertains. A very obvious one is the right to bail in the Bail Act. Section 4 of the Bail Act may be more familiar to some than others in this room, but, my Lord, the side heading is the general right to bail of accused persons and others. Now, it's trite to say that doesn't mean they have an automatic bail grant in every case. They have a right to bail, maybe a presumption to bail. But the words, the right to bail, doesn't mean they're automatically going to be given it. And closer to home, perhaps, there's the question of an appeal under the Extradition Act. At the close of every district court, lower court hearing, when a district judge orders extradition, if he does...
Surely, if an applicant for bail satisfies all the usual conditions for the grant of bail, then he has a substantive right to bail.
Of course, if he satisfies all of the conditions.
But the conditions, the substantive right doesn't arise out of a procedural right to make an application. It arises out of him fulfilling certain conditions, being a certain type of person.
And exactly the same is true here. If he is the sort of person who is not deliberately absent and had no prior information about his hearing, then Article 6 and the Romanian courts and our court require that he be granted the right to relitigate the evidence that gave rise to that conviction. And I have no difficulty with describing that as a substantive right. But he has to go through the procedural hoop of making the application, and the outcome of that application is not certain and cannot be identified with absolute certainty before it's made. So that is a helpful, I would suggest, example. My Lords...
But it's open to the Romanian court, is it not, to dispute whether this particular individual deliberately absented themselves from the trial?
Well, that wouldn't be something for the court to dispute. Would be open for a prosecutor, if he has the evidence, to dispute it before the Romanian court, if it transpires that that evidence exists. So you are not guaranteeing the outcome. You are guaranteeing the right to apply. And my lords, I was going to go on and give the example of the Extradition Act. At the close of every hearing, a district judge is required by the criminal procedure rules to tell a requested person that his extradition is being ordered and he may appeal to the High Court within the following 7 days. And that is reflecting the right which is contained in Section 26 of the Act, which, just your note, I don't need to take you to, is at page 424. But of course, that is subject to leave being granted by the High Court. Now, the requirement for leave is contained in Section 26, subsection 3, but nobody would ever characterise extradition hearings as having no right of appeal, merely because they have to be subject to permission being granted before an appeal can be progressed. It would, well, I don't need to reiterate that point. It would be quite wrong to say an extradition hearing is a hearing the outcome of which you have no right to appeal, when what you mean is you have a right to appeal it, you have to go through the hoop of an application, and that may or may not be granted. My lords, can I take you to Article 4A?
Just before you do,
yes.
Sorry, this is just going back to the answer you gave to Lord Burrows. It seemed to me that that answer was predicated on the idea that the UK court has before it Article 466, 466, and the terms on which someone could or could not be granted a retrial. But my understanding, but please correct me if I'm wrong, is that the only information the district judge had on that score was at page 353 of the bundle. He didn't even have the full text of Article 466 before him in order to even make that assessment.
He had 353,
Right.
and he had the wording in the extradition arrest warrant at 214.
214.
Yes.
He also had BP.
He had BP, certainly, which I understand is the reason that in August, well, perhaps I shouldn't give that information. There was no application for a further adjournment in August because BP was binding on him in exactly these situations. And he had, of course, the wording of 466 within BP as well.
But how was he supposed to know that it was the same wording, that it hadn't been amended or whatever? I mean, one doesn't usually prove foreign law by pointing to a decision of a UK court that happens to have looked at foreign law as it stood 5 years ago or something like that.
I am not suggesting that I think what was going on is anybody was trying to prove foreign law in front of him. They were asking him to follow binding authority of BP.
Yes, I mean, before the district judge, the Romanian authorities could come in with BP and say as long as there's an application, as long as there's a right to apply,
yes,
that's the end of the story.
And you know there's a right to apply because it's in the EAW and it's in the further information. And that was also the case in front of Mr. Justice Chamberlain.
Yes.
In fact, it was the appellants who produced the wording of 466. I know there's been a lot of criticism about the fact that it was a 2014 version. That's the one they produced.
Well, I think you can take it that this court will not be attempting to reach conclusions on the meaning of 466.
But even just on informing the judge about 466. I mean, I follow that you've got the BP authority, but wouldn't it be necessary to go at least one step further and say, and Article 466 has the same text as it did 5 years ago as considered by the Divisional Court in BP?
In my submission, it wouldn't have been necessary. It might have been preferable, but it would have been met with the argument, you're not allowed to do that. You're not allowed to call fresh evidence. What you're doing is calling evidence which would have been available to you before the lower court, and you're not allowed to do that.
Yeah, well, that's why I was asking about page 353
Yes.
and what actually was the evidence before the district judge. Anyway, you've assisted.
That's
Thank you.
my understanding, is that is the evidence that was before him. And may I clear up while we're at it one other point? The wording, the official wording, did not come out of the blue. It came from the Ministry of Justice. I've now lost the reference to the original, to the wording of it.
But I thought that text never featured at any stage in the evidence before any court, did it, other than us?
What, that it came from the Ministry of Justice?
No, so we've been shown two versions of Article 466. One, which I think you're saying is the one that comes from the Ministry of Justice, which is page 378, and the second, which was a translation via the Police Commission, which resulted in page 2528.
Yes.
I think we were told that the version at page 378 was never put before the court, either the district judge or the judge. Is that right?
That's correct. Yes. Yes, that's correct.
So that never was part of the evidence in the proceedings.
No.
I think we were told that page 2528 was produced by the appellant at the time of the hearing before Mr. Justice Chamberlain.
Yes.
But I raised with Mr. Cooper whether there was an application to admit it as fresh evidence, and I mean, unless there was and that was accepted, then it wasn't even evidence before Mr. Justice Chamberlain either.
That's my understanding.
And was there an application to admit it as fresh evidence?
Not that I'm aware of. I
Right, so
obviously wasn't there, but
so neither of the translated text of Article 466, which we've been asked to look at, was in fact formed part of the evidence before the courts below.
that's correct.
Right. Yep. Okay. Just wanted to check. Thank you.
And if it had been, it would instantly have been subject to argument, denial of admissibility, and so forth. But it wasn't. So I simply wanted to be clear, because my learned friend seemed to be suggesting this had been produced out of a hat by a liaison magistrate, who is a member of the CPS responsible for Romania. But if you look at the previous page, page 376, this is the official version from the MOJ. The gentleman called John Williams says Leanne from the MOJ.
Yes, thank you.
So that was merely as to provenance, nothing more. So may I take you, please, now to Article 4A.
Just before you do, can I just take you back to your case at paragraph 14?
Yes.
Where you succinctly state that it's the right to apply for a retrial before a judicial authority. You there emphasise, perhaps in light of the case law, that the person's entitlement thereto in accordance with national procedural laws.
Yes.
Is that essential to your submission, that they are procedural laws as opposed to substantive aspects of the law? What I'm thinking of is that your bail example, you might say that the conditions that need to be satisfied are hardly described in English law, I don't think, as procedural matters. They're matters of substance. So I'm just wondering why you are sort of linking your submission to procedure rather than substance.
There are three reasons. The first is that I was about to take you to Article 4A, which itself makes very clear that the 4A1D right has to be applied for in accordance with the procedural requirements defined in the national law of the issuing member state. That's the first point. The second is because it's clear that there are time limits involved, and that would, in my submission, be a procedural issue. And the third is because that is the language used over the last decade by the high courts in this country, both here and in Scotland, in granting extradition where there is a right to apply subject to the laws of the national state, the foreign national state.
So even though the laws of the national state are a far cry from time limits, they are actually what you would normally think of as substantive elements. That is, was this person somebody who was deliberately absenting themselves from trial or not? You say, well, in this area, that is just classed as a matter of procedure.
It has been in each of the cases I read out shortly before the short adjournment. I have no particular difficulty with them being a mix of procedural and substantive, but that is the language of the framework decision, and it's the language of the domestic courts, and that's why that word appears in my case.
Yes, you also use the word substantive in your case at paragraph 114, but I won't distract you with that. Where you talk about nor should independent judges be constrained in their application of their domestic procedural and substantive provisions by the findings made by a district judge in this country. So you recognise the distinction at least, but you say that our case law has treated what might otherwise be seen as a substantive requirement, namely that they weren't deliberately absent from their trial, as being a procedural matter.
I do. Article 4A, please. Starting at page 507. The wording of the article that's substituted for 5.1, and you haven't been taken to this yet, starts with the paragraph, the executing judicial authority may also refuse to execute the European arrest warrant issued for the purpose of executing a custodial sentence or detention order if the person did not appear in person at the trial, unless the EAW states that the person, in accordance with, and these are the words I emphasise, in accordance with further procedural requirements defined in the national law of the issuing member state, subparagraph D, was not personally served but will be personally served and will be expressly informed of his or her right to a retrial and so forth, and will be informed of the time frame within which he or she has to request such a retrial. So, on the face of the article, it is not and never will be absolutely automatic necessarily. There may be states who simply require you to fill in an administrative form. But if there are procedural requirements defined in the national law, that is not a bar. Can I, while we're on Article 4A and the framework decision of 2009, highlight a couple of other matters in the hopes perhaps of not coming back to them. I say in terms in the case, and it's correct, that we have not been able to find out why what in Article 5.1, which was deleted, was termed a right to apply for, is in Article 4A a right to.
So Article 5.1 is at what page, sorry?
I'm sorry.
What page is Article 5.1 at?
5.1, I'm just going to ask.
Sorry,
for reference.
I don't want to.
490, I believe. Thank you.
Thank you very much. Thank you.
I have to face up front the fact that there is that change. There is no evidence that it is significant. There's also no evidence it's insignificant. But what I would say is that there is a logic to it in my submission. Article 5.1, the old 5.1, allowed an executing court to request a guarantee deemed adequate in the executing state. In other words, it pushed the onus onto the executing state, if they wish to do so, to ask for a guarantee and then to decide for themselves whether that was adequate. That was causing problems. Can we please look at the recitals? Because, as you would expect, those give an indication as to why the change was brought in. 505 sets out recital 2 and 3, and there are really two reasons why the change was made and Framework Decision 2009 was brought in. The first is that of a number of different criminal provisions that were in place at the time, they had different methods of dealing with issues rendered in absentia. And there were different rules that apply. Off the top of my head, the decision as to the enforcement of fines, if taken in absentia, and the decision as to the enforcement of confiscation orders, if taken in absentia, had different rules. And Recital 2 records this diversity could complicate the work of the practitioner and hamper judicial cooperation. But secondly, and specifically in relation to the 2002 Framework Decision, and it's about half to two-thirds of the way down Recital 3, Framework Decision 2002 on the EAW and the surrender procedures between member states allows the executing authority to require the issuing authority to give an assurance deemed adequate to guarantee the person who's subject to the EAW that he or she will have an opportunity to apply for a retrial in the issuing member state and to be present when the judgment is given. The adequacy of such an assurance is a matter to be decided by the executing authority, and it's therefore difficult to know exactly when execution may be refused. And that was very much echoed by the documents that my learned friend took you to towards the close of his submissions today, the explanatory memorandum in particular. But it goes on over the page, Recital 4. It's therefore necessary to provide clear and common grounds for non-recognition. This framework decision is aimed at refining the definition of the common grounds, allowing the executing authority to execute the decision despite the absence of the person at trial, while fully respecting their rights of defence. This framework decision is not designed to regulate the forms and methods, including procedural requirements, that are used to achieve the results specified in this framework decision, which are a matter for the national laws of the member states. So there again, you get an explicit recognition of the fact that different states will have different rules as to how you go about securing a retrial. What it doesn't say anywhere is it's been proved not to be enough to have a right to apply. You actually need an automatic, enforceable, guaranteed right of retrial. And had that been a concern at European level, you would have expected, as I say, in the usual way, for it to be reflected somewhere in the recitals, I would suggest.
The right to apply might have been inadequate because it wasn't accepted as being sufficient. And it's difficult to know exactly when execution may be refused. The right to a retrial makes it absolutely clear.
That is an argument, but it is, if I may say so, speculation. There's no information about that. There's nothing in the explanatory memorandum that says that. There's nothing in the recitals that says that, and there's nothing in any of the materials that either side have been able to find that confirms that. The only thing you get is we are trying to balance, and the word balance is used in the explanatory memorandum, on the one hand, proper protection for rights, and on the other hand, legal certainty and a proper recognition and respect for the judgments abroad. My Lord, may I deal with one final matter before leaving this article, and that is Mr. Cooper's interorum suggestion that his client may be held in custody ad infinitum. He did take you to Article 4A3, but I'm not sure that he actually read out or emphasised the purpose of it. He is right, of course, that anybody who's extradited is for the time of their transfer from one country to another in the company of a judicial or police officer of the requesting state who comes to this country and collects them. However, Article 4A3 makes explicit provision for the fact that if there is an application for a retrial, the question of their detention is subject to review and is also, and this is the bit I don't think was read out, subject to the possibility of suspension or interruption of detention pending the application being heard. So it's a very small point, but it's just to...
But I think that's just referring to the possibility of bail in the requesting country.
Exactly. That's exactly what...
But I think that the main point that was being made on Article 4A3 was in relation to the last sentence, which says the retrial or appeal shall begin within due time after the surrender. And it was, yes, as I understood the submission, it was being said, well, that reinforces the point that what is meant by a right to a retrial in 4AD1 is indeed a retrial, substantively.
Well, in 4AD, that would be right. Sorry, I'm not entirely sure I'm following. Absolutely right.
So 4A3
yes,
seems to suggest that if someone has requested a retrial or appeal, the retrial or appeal shall begin within due time after surrender. In other words, that there does have to be a retrial.
4AD cuts in where the requesting state is able to confirm, yes, that
he ticks box 3.4.
Exactly.
Yes.
He is definitely eligible.
Yes.
And in those circumstances...
It's the point about the negative wording of 4A.
Yes.
That you can exercise a discretionary refusal unless, and 4A1D is ticking box 3.4, and if you tick box 3.4, then you have to give the retrial.
Yes, and you have to give it in due time.
In due time.
And he can be either on bail or in custody until then.
Right.
So
are you accepting that if Article 4A1D, which corresponds with box 3.4, is ticked, that there does have to be a retrial?
That's what the IJA has said, yes. Well, yes. That as far as all of the information is available to them at the time that European arrest warrant is issued, they are going to get a retrial.
Right, so forgive me, it is my fault, but I'm now unsure what the point of your submissions about the procedural nature of this right is. Surely, I mean, I can see that there may be procedural requirements which regulate how you make your request for a retrial, but if you go through those procedural hoops and you have made a request for a retrial, is not the effect of D1 read together with 3 that there has to be a retrial?
My lords, the answer must be yes. That is what the requesting state is saying.
You chose your words very carefully in answer to my colleague's questions, because you said if at the time the application is made, that was the position of the requesting authority, leaving open the fact that there would still have to be an application under Article 466, and it is a possibility that the court in Romania might take a different view.
My lords, I did, and the reason why I did that is because I was going to come on to deal a little bit with the practicalities about issuing.
I'll let you do so.
All right. So as far as the framework decisions are concerned, the last thing to be very clear about is that it is unlawful now for the court in this country to ask for a guarantee from the issuing judicial authority. Article 5.1 is deleted. Maloney confirms that you cannot ask for a guarantee in addition. So the question does arise if Section 25 means an automatic right. How do you satisfy that if you are the requesting state? If you don't know at the point of issue of the EAW why he left the country, there is a case within the bundles that happens, HYA, at tab 87, page 2231. I don't need to take you to it. But that was a case of force majeure. He left the country because he was deported by the Bulgarian authorities. Query whether in those circumstances he would ever be properly held to be deliberately absent. What if you thought when you issued the EAW that he had a court-appointed lawyer, because that was what happened when the writ of summons was issued, but in fact, by the time they came to trial, unbeknownst at that stage to the issuing judicial authority, the court-appointed lawyer had been in touch with him and had become his mandated lawyer. It is, after all, a very familiar process in this country that on the first hearing, there will be a duty solicitor. But by the time you get to trial, that duty solicitor is now the appointed solicitor under a legal aid order, having, to put it in slang terms, picked up the case because he was the court-appointed lawyer, but he's become the mandated lawyer. Now, of course, in this country, in those circumstances, you'd know that because he'd be on the legal aid order and he would appear and so on. But if you follow my logic through for a moment, a court-appointed lawyer for the purposes of the writ of summons, by the time you get to the trial in absentia, has been in touch with the client. The requesting state know nothing about this, but there is in fact communication between them. The requested person is still absent, and so, perfectly properly, because they think it's correct, when they issue their European arrest warrant, the requesting state tick the fact that he was only represented, or tick nothing at all, because the truth is that as far as they're concerned, there's going to be an entitlement to a retrial because he only had an ex officio lawyer. But by the time he gets back into the country, which as we well know can be many years later, further information, fresh information has come to them. It's by no means impossible that by the time you get to enforcing the sentence, you are better informed than you were at the time that sometimes some years earlier, you issued the EAW.
You're saying the Romanian authorities are by then better informed?
It's by no means impossible that they may well be, yes.
No,
So they've issued an European arrest... I'm sorry, I interrupted.
yes.
They issued a European arrest warrant 10 years ago in good faith. They had no idea to which country the requested person had gone. They didn't even know if he was in Europe. They thought he'd been represented by an ex officio lawyer. Once he is found somewhere in Europe and the European arrest warrant is executed, he returns to Romania and applies for his retrial, and they are able to rely on evidence that says that's not right. In fact, I mandated my lawyer.
I just need to have the meat on the bones of that. What prevents them from obtaining this information at the earlier stage, the anterior stage, when they're seeking extradition, as opposed to many years later when they're actually considering an application? Because
they may have no means of obtaining it, unless the...
Give me an example.
Unless the ex officio lawyer has for some reason told them, or it may be that he is instructed. Well, actually, let me give you a good example. There was a fashion a few years ago for applying to the High Court here for extradition to be refused on the basis of no right of retrial. When that is turned down, UK lawyers, in connection with lawyers in the requesting state, made applications to that requesting state for a retrial before the person was returned. And the most egregious example is Rexa, where the High Court found that there was significant non-disclosure to the Rome court. The entire purpose being to have the application for a retrial turned down in Rome in order to be able to come back to the High Court here, reopen the appeal hearing here, and say, you see, I told you he wouldn't be entitled to a retrial, now it's been turned down, so now you definitely can't send him back. So that would be an example of discovering, let's just say that the lawyer in Rome who made that application was the same one as had appeared in the in absentia trial, of the IJA getting at that late stage information that he'd in fact been mandated earlier. But it could be much simpler than that. It could simply be the IJA don't know why somebody has left the country. It could be for good reason, it could be for medical reason, and then the girlfriend makes a complaint to the police separately, and light is shed on why he left the country. My point is there's a myriad of reasons why the factual position may change in practice. So to revert to my submissions, I'm conscious that I don't have an unending amount of time. No. Where an inquiry, we're not allowed anymore to say, please guarantee to this court that you're going to grant him a retrial, because that's what the European law says. But further than that, as I was submitting before lunch, it would be quite wrong under the rule of law to ask for a guarantee of how an independent judge abroad is going to rule. They couldn't and they shouldn't give a categoric answer. Still less could a public prosecutor give a categoric answer, and still less again could the Ministry of Justice, a limb of the executive, give a categoric answer as to what is going to happen when the national rules require an application to be made.
But doesn't that just show that there isn't a guaranteed right to a retrial under the law of that state? If it's made conditional on some determination by a national judge, and I quite follow your point that no guarantee can be given how they will determine the matter because they'll apply the law, that shows that there isn't a guaranteed right to a retrial under the law of that state, doesn't it?
Well, that begs the question. In my submission, the answer is no. There is a right, not a guaranteed right. There is a right to a retrial, and you have to bring yourself within the class of persons who can benefit. And that is perfectly appropriate. It's not in breach of Article 6. It has the effect that when people go back, those who are properly entitled to a retrial under Article 6 with their defence rights respected get that retrial. Those that are not properly so entitled do not get to benefit from impunity by sitting in this country because the courts can't return them.
No, but the difficulty is this, that there are triggers or hurdles that have to be crossed before someone can be compulsorily removed from this country. They don't just end up in the country of the requesting state voluntarily or by chance. It's the fact that they are being sent there on a certain basis. Now, if that basis is thereafter negated, doesn't that call into question the basis on which they were compulsorily removed in the first place?
My answer to that would be no. It will only be negated if the courts in this country and the IJA were suffering a misapprehension as to the entitlement to the right. Because, in fact, he was not so entitled. For instance, because it turns out that he was deliberately absent. And bear in mind that not only is the application for a retrial required to be Article 6 compliant, there is a right of appeal if the answer comes back no. So the practicalities of what is otherwise being asked for is that an officer of the court, or even a judge of the court, is bound by a decision in this country made on a false basis, which their own national law would not support, which grants a right to a requested person to which he was never entitled. And that cannot be the right answer in my submission. Whereas if the words right to retrial in Section 20, subsection 5, mean the right to apply, none of those problems arise. There is, perhaps I should say, one other very real practical danger about all of this. Even if somebody in the requesting state could be persuaded to give the kind of almost sort of guarantee, but under a different name of an assurance, as is what happened in the Italian case of Nastasi, and gave that assurance in good faith, as a result of which somebody was extradited back to the country. And it turned out to be wrong because the independent judge there disagreed on the evidence. It's fairly trite to say the judge in the foreign state must make his decision in accordance with national law and on the evidence. If that judge disagrees with the good faith assurance given to this country by the official, there will be instant allegations here of bad faith and of abuse of process, or of legitimate expectation set up. Maybe that's the right answer, but the way through this is to read right of retrial as a right to apply. The final thing I might say on this is, if we are, it is very clear that Romania, whether this is a matter of their past history or what, they are extremely careful, much more so than the Italians, about not binding their own courts. And it starts with Bohm, and maybe it's instructive to have a very swift look at it. It's 10, tab 10,
just before we move to
Yes.
it, isn't another way of avoiding problems of allegations of bad faith and so on if the judge in the requesting state makes a different decision later on, to look through whatever contingent aspect of the law that judge is called upon to apply, to see whether there is actually a right, so there is no contingency, so that you can see in the law of the requesting state that there is a right to a retrial, which does not depend upon contingent judgments to be made by a local judge. As you say, they can't be bound by an assurance given by the state. And so if there is that contingency, depending on the judgment to be made by the local judge, there isn't a right in the relevant sense.
Well, what your lordship is asking for is an absolute guarantee of retrial in every case of an in absentia decision, regardless of the reason why that occurred.
Yes. What I was really putting to you was you said there's a problem here. If you send someone back and then a local judge, not bound by any assurance given by the state, makes a different ruling on some relevant contingent matter, there'll be accusations of bad faith and so on. So the relevant scheme can't have been intended to work in that way. And what I was putting, and you say, and therefore it has to be interpreted as being a right to apply for a retrial.
Yes.
What I was putting to you is you can avoid those problems, can't you, if instead of saying it's a right to apply for a retrial, in other words, letting the rights of the individual depend upon a contingent judgment of the local courts, if you say the right to a retrial is a right in the substantive law, guaranteed by the substantive law of that state, so not contingent on any judgments to be made by a local judge. And there, if that's right, you also avoid the problem that you just identified of accusations of bad faith and so on.
But what I'd understood your lordship to be saying is that in those circumstances, the substantive right to a retrial has to be not subject to any form of requirement to bring yourself within that, so that it exists whether or not it turns out you were deliberately absent, whether or not it turns out you'd mandated your lawyer, which is tantamount to saying no trial in absentia will ever be allowed to stand as far as the English courts are concerned. If we are to return people, there must always be a right to a retrial.
No, not at all. Because if you establish box 3.2, for example, if you establish that there is the person cannot be treated as being in absentia, for example, because he'd instructed a lawyer, then so be it. Once you tick box 3.4, it seems to me that Lord Sale's point has a lot of force. That what you were saying is your domestic law has no contingencies that prevents the grant of a right of retrial.
Yeah, and you only get into section 20 subsection 5 if you've gone through section 20 subsection 3, which talks about as a person who's deliberately absented himself from his trial.
But we only deal with any of this on an evidential basis if either the EAW is ambiguous or if none of the boxes have been ticked, both of which are entirely possible.
Yes, but given that the judicial authority has to establish to the criminal standard the entitlement to extradite, does that not mean that the extradition fails?
The effect of that is that unless you have cast iron evidence in the requesting state, and you know which is the right box to tick, you can't ever establish the conditions in section 20.
No, you can, because section 4A1A, if that is satisfied, the person has to go back to, has to go to the requesting state, irrespective as to whether he gets a retrial. Yeah. And indeed, for A1A, he can also be sent back even if he didn't meet those requirements, because there's a discretion. But you don't get to a retrial until you get down to D or C.
Yeah, and you only get to D when you've lost, if you've lost or you don't have a case on the other subparagraphs that would bind the hands of the United Kingdom, according to the framework decision.
Yes, because you don't know the answer. If you're in a position where you...
Sorry, when you say you don't know the answer...
Sorry.
The requesting state has to prove to the criminal standard in the extradition proceedings that one or other of the boxes or subparagraphs applies. But it doesn't need to show that they all apply, it just needs to show that one applies.
Well, first of all, they don't have to show that one applies, but if one applies, one of the four, then they can't refuse. Yeah. But if the requesting state doesn't know, or if, and therefore has genuinely not ticked any of those, but says nonetheless, if the requested person, for instance, gives evidence that he didn't know, and there's no evidence upon which to cross-examine him here, so that even if something has been put into the European arrest warrant, but it's ambiguous, exactly as we have here, and then the requested person goes into the witness box and gives his evidence.
I'm so sorry, I'm finding this a bit confusing. When you say the requesting state doesn't know, the requesting state has positively to present a case. If it doesn't know, it's not going to be able to succeed under any of the boxes, according to the criminal standard. If it doesn't know, it doesn't have a good case.
I'm sorry, I spoke, I wasn't being sufficiently clear. Unless the requesting authority has evidence that the person was deliberately absent, it cannot rely on that as a ground for automatic return.
Right, yep, correct.
So you're into section 20, subsection 5 territory. Now, unless one of the boxes has been ticked, you're into calling evidence or relying on what is in the answer to the request for further information, or listening to the defendant as to what position he puts before the court, in order to make a judgment as to whether the requesting authority has proved sufficiently, i.e. to the criminal...
But surely a well-advised accused person, if the requesting state has not presented any case at all, won't go into the witness box, because that just gives the requesting state an opportunity to try to improve its position evidentially by asking them questions. If they haven't even put in their own evidence to support one or other of the boxes, an accused person won't go into the box, will they?
But I mean, exactly as we have in this case, you have not a positive statement that somebody was deliberately absent, but rather a positive statement that they're entitled to a retrial. So, which is subject to their provisions in the national law.
I thought the positive statement was entitled to request a retrial. That's the positive statement. That's why I became, slightly fixated, you might think, on page 353, which is
exactly
where it's only put in that way. Now, I can see that there's then, a legal argument as to whether right to request is sufficient, as opposed to a right to get a retrial. And I thought, in effect, that's what we're debating here. But isn't that right?
Of course, my lord. Yes, I'm sorry. But if you just had the EAW, which is your starting point, the implication in that, because of the legal pledge, is that there is provision for the reopening of criminal proceedings. What happened is, because 3.2 and 3.4 on their face were inconsistent, the CPS, rather than relying on the tick in 3.2, took it upon themselves to make further inquiries. And of course, ultimately, it was a point taken up as well by the requested person, and he gave evidence in support of that case. So that's how this case reached a point of either further obscurity or further clarity is not entirely clear. But anyway, it progressed, put it that way.
Well, I mean, I think as Lord Burnett has made the point, there came a point when the requesting state abandoned reliance on the 3.2 box. So that drops out of the picture, and we're just left with 3.4 then.
Yes, and what they did in my submission was, although not ticked, serve the information which reflects 3.4.
Okay, yeah, thank you.
I appreciate we're interrupting the flow of your submissions, Ms. Malcolm, and forgive my adding to the interruption. But do I take it that it's your submission that whenever the Romanian authorities tick box 3.4, which I notice in the EAW has been adjusted to reflect their procedural time limit, that all they're suggesting is that someone has a right to apply for a retrial or appeal, rather than they have the right to a retrial or an appeal, which is what is actually stated in the document. Because this is quite an important point, it seems to me. If the thrust of your argument is that even in the EAW, right to a retrial means right to apply for a retrial, it must follow, given those who instruct you, that that is the understanding of the Romanian authorities, and that is what they understand to be conveying when they tick 3.4, which I appreciate they didn't in this case, but given that the version of it has a Romanian adjustment, if you remember in the EAW, there's a gap to insert the number of days,
yes,
and that reflects the earlier point you've made to us that it can be reflect the procedural arrangements in any jurisdiction. That they have never meant anything more than a right to apply.
My Lord, that is my understanding. Checking that there's a nod beside me, but that is absolutely my understanding. And the wording is, the person will be informed of the time he has to request a retrial.
Yes.
But that is also entirely consistent with the fact that it wasn't that they refused to answer the lower court.
No, it's different. It's a different point.
Well,
but if one looks at the EAW, in the framework decision, and the 3.4 has 3 sub-points. In
yes,
the version we have in translation of the EAW, in this case, the 2 last sub-points have been elided, but there are 3 quite separate sub-points in the framework decision itself. And true it is that there's a separate sub-point that requires an application. That makes perfect sense with the state concerned identifying the number of days within which it has to be made. But that is a separate point from the main meat, the middle sub-point, which is the right to a retrial.
well, all I can answer is my understanding is that's exactly what they meant. They will have the right to apply. That is why, contrary to what's been submitted to you, they weren't refusing to answer a simple binary question. On each occasion they were asked, they made the same answer, which is, here is our provision, which is the one that we identified in the AW when we first started this process, which says these are our right to retrial provisions, which, as we also know, have been put into their criminal code in order to be in compliance with Framework Decision 2009. That was the purpose of the amendment of the Romanian Criminal Code. So the previous position, which is the one that obtained at the time of the case of Bohm, there was a different provision, and it was amended to be 466 to 470.
Could I just fully understand it? Because 331, which is the European arrest warrant,
Yes?
and 3.4 isn't ticked, but the 10 days are inserted at the bottom. And the right to a retrial, which is in the second, well, just about 4 lines down, that has always been construed by the Romanian authorities as a right to apply for a retrial. Is that right?
Well, I can't give you evidence, as I don't know how they construe it, but that is the logical answer, the logical consequence.
Why did they insert 10 days if they weren't ticking that box? Yes.
I can't answer that. But I have very little doubt in my own mind, for what that's worth, that they thought they were properly and faithfully filling out the fact that he was only represented by a court-appointed lawyer, and because they mention the article of their code which allows for the right of application, that was what they were suggesting he could do within 10 days. I don't know why they didn't tick 3.4, but that is completely consistent with everything that they did in the 6 months or so between May and September in answer to the requests, first from the Crown Prosecution Service and then the district judge. And it is clear that in their national law, there's nothing automatic. They are bound by the provisions that create the need to apply. And all you have to satisfy in doing that is that you're not deliberately absent in order to have it granted. My Lord, may I take you to Bohm?
We should let you develop your submissions because time is ticking on.
Yes, I do need to take you to those 7 decisions of this country. So Bohm is tab 10. It's a very short judgment. It was under the early...
Give us the page number.
Yes, starts at page 582. The paragraph that I'm starting at is 11, which is 584. And what happened was that inquiry was made and evidence returned from a lady who was a director of the Directorate for International Law and Judicial Cooperation, therefore a member of the executive, who was, and I quote, quite clear about the operation of the then existing article. She states in her evidence that the court would examine all the merits of the request and the relevant aspects which can be deduced from the case file, including, for example, whether reasonable efforts had been made to notify the defendant of a pending trial and other aspects of the procedure. And so the conclusion is, it's quite clear that it's not an automatic and unqualified right to an actual trial. And the corollary to that is in paragraph 13. Mr. Justice Irwin says, it seems to me, therefore, that unless and until Romania take that step, which is the step of bringing their law into accord with the 2009 framework, any potential extraditee in the position of Mr. Bohm, namely tried in his absence but not deliberately absent, will necessarily not be extraditable. And that, if I may say so, for better or worse, and there may be very good reason for it, that is the direction we're heading in. That of the 150 or so Romanian in absentia applications that come to this country, if they are required to say that there's an automatic right to retrial, no matter what the evidence is in the requesting state, they will not be returned. So, as I say, if that's the consequences, so be it. May I now, please, because I do need to deal with the English case law, start and do it in the order of my case, which starts at paragraph 84 of the case. The case is behind tab 7. It starts at page 66. And I'm going to skate very quickly over the first early years. But paragraph 84, page 97 of the electronic paging. The early cases required entitlement to retrial to mean entitlement to retrial, undoubtedly. Blatter, Bogdani, Darin Chen against Romania, and then there was the beginning of the change at paragraph 89 with Gradica and Benko in relation to Hungary there, where Mr. Justice Tugendhat and Lord Justice Dyson heard evidence from a judge of a Romanian court that a retrial may be requested, and held that in light of the fact of the ECHR compliance, and in light of the fact that they misconstrue the letters from Hungary in the light of Hungary's obligation under the ECHR, section 20, subsection 5 was satisfied. Toos was the case decided in favour of the requesting state. Buller was not. It went the other way. You then get, and the chronology of this is important, you then get to what we've called the middle period, the period of the transposition of the framework decision of 2009. Armitage goes one way, and Bohm, which I've just taken you to, goes the other, because first because the law was not in conformity with the framework decision at the time, and second because the official of the Ministry of Justice was very careful to say that it was a matter for the court. Mr. Justice Irwin said it's quite clear there is no automatic and unqualified right. You then get to Rexa, and perhaps the one that we should stop and look at with a little bit more care is Nastase. Now, Nastase is in your bundle. Nearly there. Tab 19, page 720. This is, as I would suggest, the first of the line of more recent authority starting in 2012, although in fact Rexa was also in 2012 and decided the same thing. Nastase sought to differentiate, did differentiate, having rehearsed the authority starting at paragraph 29. I'm going to need to ask for a page number.
727.
727.
Thank you, 77. For the following 6 paragraphs, rehearsed what were then the cases that had been before the court, and differentiated between cases involving what they call the pure discretion and those in which there was an assessment of probability of grant. upon application in accordance with the criminal code. And paragraph 44, and in particular 45, 734, is the ratio. It was held that applying the interpretation of the authorities, in other words, the distinction in the previous paragraph between what one might term pure discretion and the application of law to the facts in accordance with the criminal code, I do not doubt the Italian court will comply with provisions of its own code and reopen the appellant's case. His entitlement to a retrial is excluded only if the court is satisfied on the evidence that he knew of proceedings and voluntarily renounced his right to appear. While there's no evidence of his knowledge, there's no basis on which his appeal could be excluded. The Italian courts can be expected to apply their own law and the decisions of the Court of Cassation. And then, which is the important phrase at the start of paragraph 45, the existence of procedural steps does not remove the entitlement to a retrial. Rather, the Italian authorities must be permitted to regulate their own proceedings by imposition of their own rules. Section 20 may create entitlements, but procedural rules set parameters within which such rights are exercisable. So that is the start of the use of the phrase procedural steps to explain or to describe the process of the application of a retrial, in which it's very clear one of the things that will be looked at is whether there's any evidence of deliberate absence. Whether or not that is more properly described as substantive, that's how they describe it.
We need to look back at paragraph 12 and the assurance that was given by the prosecutor, which was that it's necessary, however, to specify that according to the constant case law of the Court of Appeal, etc., there will be a new trial.
Yes.
Yeah.
This is what I meant by them, the Italians, being happy to give what can't be a guarantee, because that's not allowed, and what must be the assurance as a matter of evidence from the public prosecutor that in his view the Court of Appeal, the public prosecutor is telling us that in his view the Court of Appeal will decide in a particular way. And on that basis, and understandably, the Divisional Court is happy to say that what is in fact an entitlement subject to application and evidence will, so far as anybody knows, be granted. So as I say, that's the start of the phrase procedural steps. This case was applied in both Armitage and Rexa, and it was the outcome of those.
So you said subject to application and evidence. Does the Court of Appeal discuss that?
The passage I've just taken you to, 45, sorry, I closed it, speaks to the application of the law to the facts, and more specifically says in the middle of paragraph 44,
yes.
His entitlement to retrial is excluded only if the court is satisfied on the evidence that he knew of proceedings.
Thank you.
So it's clearly an evidential hearing.
It would require somebody to call it.
Yes.
The previous sentence is he's entitled to a retrial if he shows he wasn't there, and an authority for that is cited.
But that's the same in this case. There is nothing to suggest anything other than, well, apart from, and I know we've been around this loop, but apart from the ticking of 3.2, that there is nothing specific as to this requested person that suggests anything other than he wasn't there and he was represented by a court-appointed lawyer. But it's still a step that will have to be gone through to satisfy the court in Romania that he didn't have retained counsel before he gets his retrial. Otherwise, it's an entitlement. I mean, apart from that, it's an entitlement.
Well, I thought in paragraph 12 there was a positive statement in the EAW that he just has to submit the request and then he will get the retrial. Can I just check, is Rexa a decision before, sorry, Nastase a decision before it was clarified that the EAW is the source of the information about the foreign law?
Well, yes and no. I mean, the EAW has always been the source of the information, but Nastase is a decision prior to Cretu, which is what established that if one of the boxes is ticked, you don't go any further.
So this was a case where information was given in the EAW, but there was an exploration of the substantive position that lay behind that. Is that right?
The information in the EAW is in paragraph 10, not 12.
Oh, sorry.
The information, it's very misleading.
Yes, I see.
What happened is, what was there was paragraph 10. Then there were 4 further sets of information provided by the judicial authority. It is the public prosecutor responsible for the earlier information who writes to this court. I'm sorry, who writes to the lower court, and says we cannot assure that Nastase will be subject to a new trial. It is, however, necessary to specify that according to constant case law, if he submits his request, the Court of Appeal shall grant. But there they were saying, in terms, we can't assure you of that.
Well, they're also saying in terms, if he requests it, he gets a new trial. With the consequent celebration of a new trial.
Not quite. They're saying that in accordance with constant case law, we can tell you that if he submits, the Court of Appeal shall grant with constant celebration. In other words, can I try and give this illustration? Jones was a case eventually where it was decided that his Article 6 rights were not breached because he had the right to a sufficient retrial or rehearing, because there was the right to call fresh evidence in the Court of Appeal upon his appeal, if appropriate and in accordance with the laws of the Court of Appeal. If an English lawyer had been asked to opine which way the Court of Appeal was going to jump, I'm sorry, jump is the wrong expression, but whether they were going to grant the application to allow fresh evidence, which in fact is not an easy application to win, but if an English lawyer had been asked to opine in Jones when he applies for a retrial, in the light of the fact that he was convicted in absence, will he be allowed to put fresh evidence before the Court of Appeal? In all conscience, the best anybody could have said was, the right exists in law, all other things being equal, my opinion is either yes, he will, or no, he won't be allowed to call fresh evidence. But of course, I must say it was an extradition, you'd have to have said yes, or we wouldn't be in this territory. So, no lawyer can genuinely say what is going to happen as the outcome of an application in court. That's the highest it could have been put. But if it's put that way, if going forwards what we are requiring is a statement from the requesting state, and it's caveated perfectly properly by saying, I am a member of the executive, I cannot say, but in my opinion, on what I've seen on the file, There is no evidence that I have seen that he is deliberately absent. I can think of no reason why the application should be turned down. If that perfectly properly caveated statement is made, it arguably wouldn't satisfy the burden and standard of proof to the criminal standard, and you can be absolutely certain that the requested person will be arguing that in every case. That's not good enough. May I take, in light of the time, may I take it that BP has been sufficiently, for the time being, done? Thank you. May I then take you to Taranenko, which is Mr. Justice Dove in 2020, tab 27, page 816. And this is where I obtained the phrase, which I appreciate has already been subject to some judicial comment, but Mr. Justice Dove decided, on the facts of this case, or more as a matter of pure law, in the middle of paragraph 32, the fact that the entitlement to a retrial may be subject to what, again, he calls procedural requirements, which must be satisfied before the right to retrial arises, does not mean that the appellant is not entitled to a retrial, or the requirements of section 20, subsection 5 have been breached. And he goes on in the penultimate paragraph of all, paragraph 33, and this was a case where there'd been an application already for annulment which had been refused. But he says the fact that it was refused does not demonstrate the appellant was prevented from being entitled to a retrial. It demonstrates the court would not satisfy that he met the procedural requirements set out in the domestic law and was therefore excluded from exercising the right. It doesn't mean that he wasn't entitled to the right. And that's where I got, at the start of my submissions, the distinction between having a right and being in an evidential position that you can exercise that right. And I then go to Dumitraki, which is tab 15, page 666. This is a decision of the now Lord Chief Justice, sitting with Mrs. Justice Chima Grubb. They upheld the decision in BP and held that one intervening single court judgment in between had been per incuriam nastasi. And Lady Justice Carr, at the conclusion of the case, paragraph 72, it's not 72, it's 75, said the existence of a procedural step did not detract from the unconditional nature of the legal right to a retrial. This is the approach approved by the Divisional Court in BP. She also spoke at paragraph 84 to the need in extradition cases for a cosmopolitan approach, surrender under the 2003 Act being a form of international cooperation between member states with different procedural regimes. It is not for the English courts to impose English practices on other member states before extradition can take place.
Sorry, which paragraph?
Sorry, it's 84.
Thank you very much.
as it is succinctly put by the respondent, Italian criminal procedure is not to be treated as if it were English. This is not what Section 20 requires.
What was the procedural requirement to which Her Ladyship was referring in 75? Was it the 10-day time limit in Italian? I just haven't picked it up myself. I just wonder what it was.
The facts in this case are at paragraph 9 that in a similar way, according to the EAW, he did not appear in person, but he was represented by a court-appointed lawyer. As I recall, what was being sought to be argued was that Nastasi had been superseded by the judgment of Mr. Justice Fordham in Ogriano.
Just can't find it. I mean, Nastasi was a time limit case, of course.
I'm sorry?
Nastasi was a time limit case. That was the procedural issue.
At 64, she says, there is first the question whether or not the appellant was present in person, as he stated in evidence he was. Second, the entitlement to a retrial under Section 25 on... I'm going to ask Mr. Hyman to identify what the particular issue was.
Thank you.
And remind me, I think that's going to be quicker in the long run.
I think it's 33.
33. Oh. I'm very helpfully being told that the appellants think it's paragraph 33. The applicability of Article 175, which is the retrial provision, in Italy, the question of whether the requested person can prove they couldn't comply with the time limit by reason of force majeure or a fortuitous event.
Well, don't take time on it now, but it looks like it's a time limit case again.
The next is Galuska, which is at tab 16 at page 687. And this was... this one we have the head note because of the nature of the report. The question was the burden that could be placed upon the requested person as to what they might have to prove. And Lord Justice Bean said, I disagree that the requesting state must show no burden would be placed on the extradited person to disprove deliberate absence as a precondition to invoking retrial entitlement. So this is a similar deliberate absence point. I don't go so far as to endorse what appears to have been a provisional view of Lord Justice Carr at paragraph 83 that any burden imposed is irrelevant. But if the law were to place on the applicant a burden which was impossible to discharge in practice, such as arguably a requirement to prove lack of knowledge of the hearing beyond reasonable doubt, it would be difficult to say that the requested person is in reality entitled to a retrial.
Which paragraph?
So that is paragraph 25 at page 697. So this is again complying with the requirements in Italy the way that the Italian law read was you're entitled to a retrial if you can prove blameless lack of knowledge, in other words, that you weren't deliberately absent. And the question was, are you entitled, within the meaning of that word, if you actually bear a burden of proof? Answer, the burden is evidential to raise the lack of knowledge. That is a procedural requirement. You are still entitled, in inverted commas, unless, paragraph 25, the burden is impossible to discharge. Plus, in addition, paragraph 26, you assume compliance with Article 6, and you assume that the procedural requirement is consistent with the word entitled. So that is, again, very clearly a case where somebody was going to have to prove, when they got back to Italy, that they came within the class of persons entitled to benefit from rights of retrial, because they would have to, at the very least, raise the question that they were not deliberately absent, and that matter was going to have to be investigated in Italy before a retrial was granted. The case of Tejo is 2021, tab 18 at page 708. A decision of the High Court of Justiciary as to the position in Scotland. Put briefly, they endorse the position in Nastasi. There doesn't have to be an automatic right of retrial. Sorry? No, I said that.
Where do we see the relevant paragraph?
Got it. They refer to the Cretu decision and to Nastasi at paragraph 43, and endorse the comments of Lady Justice Carr at paragraph 42, those being the bit that I have referred to just now, force in the submission that there was confusion between two distinct issues: who bears the burden of proof in establishing matters identified in section 20, and who bears the burden in Italy as a matter of Italian law of bringing him or herself within the conditions for obtaining a retrial. So, again, very clear that there was going to be an evidential, what the Lordships might call a substantive hearing in Italy, that nonetheless satisfied the requirements of an entitlement to retrial in section 20, subsection 5. My Lord, it remains only for me to deal with the first instance decisions in Holland that have been produced before you, and the one Danish case. And I need only, I think, be very brief about this. The Dutch law requires an unconditional right. That's what's said in terms, and it's set out in the judgment that you were taken to.
Just give us the page number.
The 2530, tab 101, is where the judgment starts. And so the paragraph that I'm referring to, which is unnumbered, will be 4 pages further on, 2533. So first, as a matter of law, what was being decided in Holland is that there was no unconditional right, which was what is referred to and required by their national law, Article 12D OLW. The same is true for the other judgments in Holland. They were looking at the satisfaction of domestic law there. Same with the Danish court. With the greatest respect, I would suggest, does not assist this court greatly to know how a first instance judge in a different state interpreted the law in relation to their own domestic law on return. It is certainly nowhere near the kind of thing that had to be disclosed. There's absolutely no information that the Romanian authorities even knew why the return had been refused in these occasions, nor do we know if this is, well, it can't be subject to appeal because there is no appeal. But it is very often the case that a requesting state is just told, Joe Bloggs, extradition refused. But it's absolutely not the case. Even if they knew that they had a right, a duty to disclose, there's a very specific disclosure duty in extradition cases, and it requires the case to be fundamentally destroyed. And the authority for that is Raisi.
And what's the name of the case, sorry?
For the duty of disclosure?
Yes.
It's Raisi, R-A-I-S-S-I, against the USA. It was a 2013 case, and the point is that there's a completely different duty of disclosure in extradition, and a very much stronger one. I'm sorry, I mean, as in, there has to be a very significant, it has to be information that amounts to fundamentally destroying the case. But in any event, this is irrelevant, quite frankly, whether or not something did or didn't comply with Dutch law. It might have been different if there had been a preliminary reference to Luxembourg, and it certainly would have been different in my submission if there were a CJEU decision on what the entitlement to retrial means, but we're not in that territory. My Lord, I was going to sit down unless I can help further.
Well, your timing's perfect. Thank you very much indeed. Yes.
My Lords, thank you. I have just a few points to make in reply, if I may. Thank you. This is going to start rocking. Yes, my Lords. The first point in reply is just to clarify, in case any clarification would be helpful, that it certainly was not the appellant's case that every extradition case requires expert evidence addressing foreign law. That won't be found anywhere in our case. The appellant's case is that very different, that this EAW only had to tick the right box. Here, the judicial authority chose to advance its case by reference to Romanian law in the further information without providing that law and without serving the law that it chose to advance to try to make out its case, and without any explanation addressing it. And just to be clear as to the facts and the procedural history, Article 466 of the Romanian law, the official translation, was not in fact provided, I've clarified instructions on this, was not in fact provided to the Administrative Court for the substantive appeal hearing at all. It was served by the appellant after the judgment was handed down, simply to assist the court with the certification hearing point of law. So to answer my Lord Sale's point, that there was no fresh evidence application made for the Article 466. for the substantive appeal hearing, or even at the certification stage. It's reference page 266. And the learned friend has been good enough to confirm our understanding, as set out before, was correct, that the document provided by the Romanian authorities was not served or relied upon at any stage. And, my lords, the second point in reply is that the respondent's key submission, which interprets, seeks to interpret section 25 as requiring less than a right to a retrial, but in fact a right to apply for a retrial, is firstly contrary to the clear statutory language, and secondly contrary to the clear principles of conforming interpretation. And the reference here is page 1031 at paragraph 203 of Sonnet, where Lord Mance explained that the main constraint the main constraint on conforming interpretation is that such that the result must go with the grain or be consistent with the underlying thrust of the legislation being construed. And the underlying thrust of this legislative provision is quite simply to provide a right to a retrial itself, not to a lesser application, which frankly, the respondent conceded, the outcome of which was entirely uncertain in this case. And thirdly, my lords, this is another factual point, which is that in my submission, the true factual position was misrepresented in the respondent's submissions, because the EAW box 4, or perhaps the EAW was misinterpreted, because the EAW box 4, just to go back to it one last time, this is, well, starting at page 330, and this is the only, as I said before, the only factual evidence in this case advanced by the judicial authority that has a criminal standard of proof. It is that, quote, being aware of the scheduled trial, he, the appellant, had instructed a lawyer who was either appointed by the person concerned or ex officio. So what that means is categorically he was aware of the scheduled trial on this evidence, and secondly, that he had instructed a lawyer, and that lawyer was either appointed by him or by the court, but in either scenario, he had instructed the lawyer. That's what the evidence states there. And then the box 4 clarification doesn't contradict that assertion that he gave the instructions. It only adds that the public defender was appointed by the court. So it doesn't negate or contradict the factual evidential assertion that the instructions came from him, and that matters in my submission. And so what we have as a consequence is that he had instructed a lawyer, well, I hope I've made that clear, and so what wasn't clarified was, the further information that followed, was the appellant's awareness, the fact of the appellant's awareness of the scheduled trial, and the fact that he instructed the lawyer. So that evidence remains intact. And so I hope that assists on the factual point, because a lot was made of that on an incorrect factual basis in reply in my submission. The fourth point is, in my submission, another misunderstanding, perhaps, because reference was made to the issue of what was asserted in the appellant's case as to common ground at first instance. And yes, it's page 34 of the bundle. Paragraph 16, where the appellant, in his written case, was setting out some of the history, and at 15, the district judge first addressed the 23 issue by finding the appellant was not to be absent, so and then that the judicial authority did not contempt that process. And then 16, the agreed position, therefore, was that the EAW that the EAW failed to prove presence at trial via the lawyer or deliberate absence. And so the appellant's case there was simply setting out the factual position at that stage of the proceedings, based asserting what the only possible interpretation of the EAW itself was. And if I then refer, my lords, to the judgment of Mr. Justice Chamberlain at paragraph 21, it's page 128 of the bundle. So it's page 128, paragraph 21. The foot of the page, the judge there records 4 lines down on paragraph 21. It was common ground that the EAW did not show that the appellant would have a right to a retrial, nor did the further information provide the necessary certainty. So that was just a statement of obvious about the EAW itself.
This is recorded in Mr. Hawkes' submissions.
It is, yes. Yes. And then, my lords, the next, just because this was specifically raised as an important point, if I can refer, my lords, to page 293 of this same bundle, we have here the respondent's notice, which was served on the High Court in response to the appellant's appeal. And it's paragraph 30, which do my lords have EF 293?
And remind me, this is?
So this is the respondent's notice, my lord, where the respondents set out their position under the heading submissions. The respondent accepts, as it did at first instance, that the original endorsement to the EAW is ambiguous. Box D 3.2 provides that the applicant was represented by a lawyer, but it is unclear whether the applicant instructed the lawyer himself or the lawyer was ex officio, which is one of the points I've just made. This is important since it goes to whether the applicant was deliberately absent from trial and so on. Additionally, in the EAW, the respondent included partial information about retrial rights without setting out the complete nature of the right and or expressly endorsing box 3.4, D3.4. And then over the page, electronic reference 294, paragraph 31, the district judge was not, this is what the judicial authority, the respondent itself, is explaining. The district judge was not satisfied with the contents of the EAW. See paragraph 16. Accordingly, he sought further information under 15.2. In direct reference to the contents of the EAW, he asked whether the applicant would have a right to reopen the criminal proceedings and therefore request a retrial. The simple question demanded a simple answer. And then this, the respondent said that the applicant would have an automatic right to reopen criminal proceedings within a specified time frame. So that was the position of the judicial authority at that stage of the proceedings, after the extradition hearing, after the judgment of the judge, and before the matter came before Chamberlain J. And so, my lords, the next point is that the respondent, the domestic cases addressing retrial rights, we have addressed, in our case, from paragraphs 91 to paragraphs 109. And we've provided also, after addressing the facts and the key passages, our submissions on what we say is the correct approach. I believe all but one of these, of the list Ms. Malcolm gave just before lunch, post-date EP, they generally rely on the stase. And it's important in my submission to focus on the facts that gave rise to these judgments and the various different rare facts that arose in each case. And so the stase is addressed at paragraph 99 of our case. And as my Lord Burnett observed, page... The stase. I'm just going to pull up the stase. This is... The stase is at tab 19, which doesn't help, but it's page 720 of the electronic bundle. And, well, my lords will have this well in mind because you were taking this very, very recently. But the important point here is that we have the judicial authority engaging with the request for further information. We have it assisting the judge here deal with the statutory issue properly by giving evidence as to what its law is and how it operates, and very clearly giving a very clear and categorical position. So we have there, at bundle page 723 in Nastasi, clear evidence of a new trial that will be given to Nastasi, where the Court of Appeal shall grant an out-of-time appeal. And so this is the outcome of a procedural step, being what one may describe as something of a foregone conclusion. In the Stasi, the law was explained, and it was clear what would follow a request for a retrial. And then at BP, which I know I've dealt with already, but just a short reply point. Please submit, as Lord Hodge invited me to confirm, that this is tab 11, and it's paragraph, well, page number 596 at paragraph 44, that where Mr. Justice Cranston stated, to my mind, the appellant has an entitlement in this case to retrial in Romania based on Article 466. He relied on his analysis that there is no discretion in Romanian law to deny that right. Well, that's simply wrong. And secondly, he went on to describe it as a procedural step, as described in the Stase. Well, we've seen what it was in the Stase. That was more akin to a procedural step, but this was a substantive. This application involved a substantive issue being determined. And in fact, as I said earlier, the outcome of that application could only go against the appellant on the available facts before this court. And so, in my submission, regrettably, not all of the cases relying on the previous authorities necessarily picked up on the factual distinctions that arose, that gave rise to some rather broad statements. And so, hopefully, this court has that ability to that further better information to enable and to be distinguished as appropriate. And so, yes. So far as the Dutch decision is concerned, my lords, we provided the translation of the Dutch law. I'll just provide the reference to that. It's also reply authorities, tab 1 in the hard copy, page 7, and it's section 12 of the Dutch law that was applied. And what one sees there is really a replica of 4A test. And so
this is page
7 of tab 1, where section 12 starts with, it is possible to refuse to surrender a person if the EAW seeks to enforce a custodial sentence or measure where the suspect did not appear in person at the proceeding, unless it is stated in the EAW. And one sees there the court is more than familiar with that sequence. And so one sees here that it's not sort of the law, the Dutch law is no different to 4A, and in fact it follows faithfully 4A. But what's significant about the judgment is a very clear statement, a matter of public record, by the Romanian authorities to the Dutch court as to what it concedes is the scope for doubt that exists as to the retrial right under Romanian law. That can't be ignored. And the fact that it doesn't guarantee the reopening of the trial, but no more than a possibility. So those are their own words, which they placed on record. And page 24, I see, page 24 of the same, of the same reply authorities, tab 1, the same Dutch law. My lords have the replica of the same 4A pro forma.
It is a little different, isn't it? The person concerned will be expressly informed about his right to proceedings to have a default judgment set aside.
I'm sorry, where's my lord reading from?
It's not
3.4.
Doesn't reflect 4A in terms, does it?
Yes. I don't know. My lord, I don't know if it's a translation issue or not, but I was.
It's the same language in the translation of Article 12.
Yes. So, in any event, that's the law appears to follow the same format of the framework decision in providing the law, and then following that with the model format of the European arrest warrant, in order to provide for consistency of approach. My lords, I'm conscious that we have been over a lot of the same ground more than once, and
there's no need to repeat yourself.
No, and so I was only going to say that I will. I hope that the points I've made in my opening don't need to be reiterated following the respondents' submissions, but the short point is my submission they haven't been properly answered by the submissions that follow, and in my submission it was clear that there's too great a level of uncertainty that follows from the evidence served in this case as to satisfy the statutory requirement. And so that is enough in my submission. And so I really only wish to reiterate and adopt the submissions, which I hope are clearly set out in writing in both
the case and the reply. You don't need to adopt them. This court will look at your written submissions and that of Ms. Malcolm, as well as what you've said orally.
Indeed. Well, unless I can assist my lords with any particular points arising, those are my submissions in reply.
Thank you very much. It only remains for the court to thank counsel for their helpful submissions and also thank those who have assisted counsel in the presentation of the appeal and the preparation of the documents for this appeal. This case and its predecessor yesterday raise interesting questions about the Extradition Act, which my colleagues will have to think about carefully. We will produce a judgment in due course. Thank you. The court will now adjourn.